make the obtaining of accommodations either in college or the SAT much more challenging. So a parent can certainly request an evaluation at any time, and it is good to try to time that request so that there is an evaluation, ideally either late junior year or the first half of senior year. Once you get past the first half of senior year, school systems are very reluctant to undertake an evaluation because they see it as moving towards post-secondary rather than addressing their own obligations. There is a question that we have also: what colleges are affordable and how to get scholarships? At the end of the slides, there are a number of websites, and one of the best is Think College. Think College is a very good website in terms of colleges that provide services and are particularly welcoming to students with disabilities. So I would navigate that. It's a very comprehensive website, and that should be helpful. The second question, or the third question we have, is if my child has been placed into a school by the district, I think a private school, they're saying, the 504 or IEP is no longer an issue, so how do I incorporate OVR? First and foremost, if a school district places a child into a private school, the only way that an IEP or 504 plan is not an issue is if it is what we call a settlement in lieu of FAPE, where the school agrees to pay for the private school, but is saying we do not have responsibility for what goes on there. That's usually the result of a due process claim seeking either tuition reimbursement or compensatory education, and there's a settlement where the school district says, we'll pay for the private school, but don't ask us to monitor it or provide an IEP. If a school system simply says, we can't provide an appropriate placement, and we're going to send this child to a private program, there still must be an IEP in place in that second situation. In either case, the family can always go directly to OVR, ask for an OVR evaluation, and ask for a meeting between OVR either as part of the IEP or 504 process, or simply as a meeting with a private school if there's no IEP involved. Most private schools recognize in the secondary phase of their instruction that they need to participate with post-high school programs and ask for a planning session with the private school at which OVR will be invited. And you can always ask OVR to do their own evaluation. That is a service that OVR provides. Thank you, Nancy. Sorry for the interruption.
Oh, thank you. And I'll just add with regard to reaching out to OVR, as new plans by the states are being developed, and this money has been made available for these pre-employment transition services that are available for students who are not necessarily eligible for OVR's full services. What we're seeing proposed by many states is to start a wait list for some OVR services that would not apply to the pre-employment, the PETS, the pre-employment transition services. So you can actually, in most states with the OVR-like agency, you can sign up first for pre-employment transition services and then start the process to be evaluated for OVR eligibility. And that would ensure that the student would still be getting access to those transition services even if they ended up on a wait list for the other services. So let's move on to employment protections. And I do just want to note, as we're moving into this, these employment protections under the ADA would apply to students who are in a part-time job and also doing some sort of post-secondary work or a paid internship. So if you yourself are like, oh, I have a student who's definitely going to be going to a post-secondary education, maybe this isn't something I need to know. Listen, it is something you need to know. And of course your student would need it afterwards, but many students are employed during college, and many universities are now having requirements for internship programs. So regardless of where your student is going, I think this is really good information. So who is covered by the ADA, the Americans with Disability Act, and these protections for employees? Private employers, state and local governments, employment agencies, labor organizations, and labor management committees. Okay, but am I protected by the ADA? That's our next slide. if you have a disability and are qualified to do a job, then yes, you are protected by the ADA. The ADA defines a disability as a physical or mental impairment that substantially limits a major life activity. And the other important thing about the ADA is it doesn't protect you just if you have a disability. It protects you if you used to have a disability. It also protects you as if you are perceived to have a disability. And I think that's an important distinction to remember. If you're applying for a job, so we're going to first talk about the application process. An employer cannot ask you if you have a disability or ask about the nature or severity of your disability. However, an employer can certainly ask you if you're able to perform the duties of the job that are advertised with or without reasonable accommodation. They can also ask you to to describe or demonstrate the actual activities of a job. And you could ask in an interview process, if you were being asked, say, maybe to do a fine motor skill type work with your fingers that you would maybe need an accommodation for, you can ask to be given that reasonable accommodation in that interview process. Do I have to tell the employer during the application process that I need an accommodation? No. The ADA does not put that requirement on an applicant. So you don't need to inform an employer beforehand about the need for a reasonable accommodation. You just volunteer that, in certain situations if you needed to, but there's no requirement on you to do that. Okay, so when do I request an accommodation? You can do that at any time during the application process. You could also do that at any time while you are employed. But the important thing to remember is that you have to do it. There's no onus on the employer to ask you if you need an accommodation. In fact, there's laws against how they can ask those questions like we've talked about. So if you need an accommodation, you have to ask. The next set of slides talks about, does an employee need to tell the employer about the disability? While the ADA says employers are only required to provide accommodations for employees who are experiencing problems because of a disability, again, it doesn't require the employee to tell the employer. So the only way they're going to know if you have a disability and you need an accommodation is if you let them know. There's no similar, child find obligation under employment laws like there is in the IDEA. So once you've decided that, yes, I need to request an accommodation, what kind of information do you have to provide or can the employer ask you about from a medical perspective? Employers under the ADA have the right to request sufficient medical information when you ask for an accommodation. And if you don't provide the information that is requested, then the employer can deny that accommodation request. So what do these accommodations look like? What kind of accommodations could you request? So the first rule or the first test is that accommodation has to be reasonable, a reasonable accommodation. What do reasonable accommodations look like? It could be something like making an existing facility accessible, a part-time or modified work schedule, acquiring or modifying equipment, providing qualified readers, or reassignment to a vacant position. I also want to point out here when we're talking about reasonable accommodations and equipment, that's another place going back to IEPs, where in those transition services and those transition goals, some of your students' goals could be how to use the assistive technology that they're entitled to under the IEP in a workplace environment, how to use that assistive technology in a community environment, so that they're not just learning to utilize their screen reader to do a reading test on a computer, but they're learning how to use that screen reader to read emails in a place of employment or to do job research on a computer. What is not a reasonable accommodation? That's our next slide in this group. Removing or eliminating an essential function from a job, lowering standards, or providing personal use items. So what you see there is that things that are not reasonable accommodations are very similar to things that we talked about earlier, which were not appropriate academic adjustments. Lastly, there's kind of this catch-all of undue hardship. So a change or modification will not be required if it will cause an undue hardship to the employer. Undue hardship, when someone's looking at that, they're looking at whether or not there is significant difficulty or expense, and it really focuses on the resources and circumstances of the employer. It refers not just to financial difficulty, but also back to that fundamental alteration of the business. And again, I think that it's important to note that this is a key difference between the rights for a student with disability under the IDEA and the rights for a person with disability in an employment context under the ADA, where we are sometimes looking at, does the place have the means to provide that accommodation, whereas in the education context, that's not what we're looking at under the IDEA. And with that, I will turn it over to Dennis to go over some additional issues for students moving into adulthood.
Thank you, Nancy. The next matter that I would raise is that adolescents with disabilities at age 18 are eligible for SSI without regard to parental income. Only the young person's own assets and income are considered. And so we frequently create special needs trusts in order for adolescents to qualify for SSI if they have some resources of their own. They can only have about $2,000 in typical liquid resources, bank accounts, stocks, IRAs, anything like that. And their income level typically has to be below, depending upon the source of the income, $700 to $1,000 to get SSI. Most individuals 18 do not have much income, and so long as they have a functional limitation that prevents them from obtaining and maintaining full-time employment in the competitive realm, they may be eligible for SSI based upon a disability. And the great thing about having SSI, not only can you get a check of up to about $750 a month, if you get $1 of SSI, you automatically get medical assistance